Awesome. Welcome everyone back to Moot Court Madness. We are down to the Final Four. Today we have two amazing teams, Baylor and Arizona State. Baylor with Elizabeth Gardner, Lauren Johnson, Lainey Howard as an alternate, and Kathy Sear, professor advisor. Arizona State, Anthony Studnicka, Jada Allender, and Aaron Hernandez as advisor. It was an amazing competition yesterday. Congratulations, both of you, for making it on to the next round and competing today. It's been amazing to have you guys. And I want to thank you all again. It's been incredible because for the viewers at home, this was all put together in under 2 weeks. So it is an incredible feat that the law students were able to digest all of the information and be able to actually argue it in moot court in under 2 weeks, while also still being in school and taking their courses right now. Kudos to you guys. Incredible job. I'm going to go ahead and do an introduction of our three amazing judges for today, and then I'm going to kick it back to the law students to once again give an introduction for themselves before we begin. So, three amazing judges today. Jody Balsam is Associate Professor of Clinical Law and Director of Externship Programs at Brooklyn Law School. She is a recognized authority on sports law and teaches the sports law course at both BLS and NYU School of Law. She writes and speaks on sports law topics, including as co-author of William Roberts, Sports and the Law, the leading law school casebook in the field. She is on the editorial boards of the Journal of Legal Aspects of Sport and the international sports law blog, Law and Sport. She is a past chair and current executive committee member of the Association of American Law Schools section on law and sports. The NCAA named Professor Balsam to the inaugural NCAA Independent Resolution Panel, which hears complex infractions cases that implicate college athletics core values. Before joining academia, Professor Balsam was the NFL's Counsel for Operations and Litigation, a litigation attorney with Simpson, Thatcher, and Bartlett, LLP, and a law clerk in the New York Federal District and Circuit Courts. Thank you very much for being here, Jody. Zach Kurtz, or the sneaker lawyer, has become a renowned expert in the overlap of fashion and law, specifically footwear. Zach's first big win after law school was a trademark infringement case against one of the global leaders in the sneaker industry. Since then, he has been a pioneer in the sneaker law industry and created Sneaker Law Firm to educate and assist brands and creatives. He currently represents athletes, agents, influencers, entertainers, sneaker designers, small businesses, and large corporations alike, and is practicing sports and entertainment law, intellectual property, and other general practice areas. Thank you for joining us, Zach. Dave Ridpath is beginning his second decade as a tenured faculty member with Ohio University and its prestigious sports administration program as an associate professor of sports business. Prior to Ohio, he was an assistant professor of sport administration at Mississippi State University and has over 15 years of practical experience in intercollegiate athletics and administrative and coaching capacities at Marshall University, Weber State University, and Ohio University. Dr. Ridpath is often cited by major worldwide media outlets such as the New York Times, Time Magazine, CNN, and ESPN as an expert on NCAA and intercollegiate athletic matters due to his research and practical experience in the industry. Dr. Ridpath has appeared before congressional committees and has served as an expert witness in numerous cases involving intercollegiate athletics and college athlete rights. We are very grateful to have you here with us today, Dave, Jody, and Zach. Thank you so much. If I can, I'm going to go ahead and let the law students give a brief introduction of themselves and what we would love to hear what you guys want to do after law school. Some kind of tidbit would be fantastic. And Jada, I'm going to go ahead and start with you and Anthony.
I'm a third-year law student at Arizona State University. I'm JD and a concurrent Master's of Sports Law and Business, and at a firm out here in Phoenix.
Great. Anthony?
Hi, everyone. I'm Anthony Studnicka. I would like to first say thank you to all of our friends, family, alumni, fellow classmates for all the support they've given us through this competition, and those who are tuning in today, give them a shout out and say hello. I'm also a third-year law student at Arizona State, concurrently pursuing a JD and a Master of Sports Law and Business. I don't know exactly what I'll be doing after graduation in the bar exam, but I hope to intertwine sports and the law, hence why I'm here today.
Great. Lauren?
Hi, my name is Lauren Johnson, and I'm a 2L at Baylor Law School. And after graduation, I'm not entirely sure what I'll be doing, but I am pursuing a track in real estate and natural resources law.
Hi, I'm Elizabeth Gardner. I'm currently a 3L at Baylor Law School, and I plan on entering into labor and employment law after I graduate. And I'm excited to be here today.
Great. Thank you, Elizabeth. Before we get started, Jada, we did have some, it seemed like the voice was kind of cutting in and out. I'm not sure, but if there's anything you can work on, that'd be great on that end. I'm going to give a brief introduction of some background history on this case for the viewers at home so they understand, because parts of it are actually very confusing, and then it'll lead in perfectly to our moot court competition and where the case is at today. So just a brief background. The Alston case is different than O'Bannon, which was limited to name, image, likeness, because Alston was originally challenging the entire array of NCAA amateurism-based compensation limits. The student athletes originally alleged that the NCAA and 11 athletic conferences violated antitrust law by fixing the price of scholarships and other benefits. And Alston was arguing to create a free market. The district court found for the athletes, holding that the NCAA must allow for certain types of academic benefits, such as computers, science equipment, musical instruments, and other tangible items, not including cost of attendance, but associated to academics. But why was the holding about education-related benefits when Alston was originally filed to challenge the amateurism model as a whole and attempt to create a free market? Well, this actually goes back to when I was in law school. You can see that the district court was bound by the O'Bannon 2 decision, which prohibited an open market for the student athlete services, and the remedy from the court was limited to education-related benefits. Basically, the O'Bannon 2 decision created an education limitation. So if Alston still wanted a free market, then Alston would have to argue that O'Bannon 2 was wrongly decided at the remedies phase. You can see Justice Thomas's dissent in O'Bannon 2, but just to paraphrase the justice so everyone at home can understand why this case has gone from talking about free market in 2014 to now only education-related benefits. The majority in that case looked at whether allowing athletes to be paid NIL compensation unrelated to education is virtually as effective in preserving amateurism. And Justice Thomas said the court should have looked at whether allowing athletes to be compensated for their name, image, likeness is virtually as effective in preserving popular demand for college sports. So essentially, the antitrust analysis was about the concept of whether it is about the concept of preserving amateurism or preserving consumer demand, with amateurism only being relevant as it relates to consumer demand. Since the majority in O'Bannon 2 looked at preserving amateurism, it provided a form of antitrust immunity to the NCAA because it foreclosed the free market argument and the limits and limited the judgment to education. And that is where we find ourselves today with the case at hand, Alston. So we are going to be thrilled to have this moot court competition. And I believe Arizona State is representing the petitioner, the NCAA, and will be going first, correct?
Yes, I'll be going first. Can you hear me better now?
Yes, thank you, Jada.
And also, as an initial matter, with the court's permission, we'd like to reserve 2 minutes for rebuttal.
Perfect. Yes. So granted. I'll just get my timer ready. Great. So let me just and judges, feel free to, at this point, even though you're not able to be seen, you can still talk and ask questions at any point. I will give a 5-minute warning and then also a 1-minute warning. And that 1-minute warning, judges, please, no more questions. We're just going to let the students finish their thought. And Jada, whenever you are ready, I will start the timer.
All right, thank you. May it please the court, and good afternoon. My name is Jada Alder, and I, along with my co-counsel, Anthony Studnicka, represent the petitioner NCAA in this matter. I will be discussing how the Ninth Circuit erred in not using an abbreviated deferential review instead of the rule of reason analysis, and Mr. Studnicka will explain that even if the rule of reason analysis applies, the NCAA has not committed an antitrust violation. Your Honors, the NCAA respectfully requests that you reverse the Ninth Circuit's ruling and hold that the detailed rule of reason analysis should not be applied here for 3 primary reasons. First, as recognized by this court, some horizontal restraints on competition are essential if the NCAA's product is to be available. Thus, an abbreviated deferential review is appropriate. Second, established precedent supports the resolution of similar cases without a detailed rule of reason analysis. Third, this court has recognized that when there is a joint venture like the NCAA, if the joint venture's distinct product can exist only by horizontal agreement, restraints reasonably related to defining the product are valid and should be upheld without further analysis under the rule of reason. In Board of Regents, this court recognized that league sports are perhaps the leading example of an industry in which horizontal restraints on competition are essential if the product is to be available. This court further explained in American Needle v. NFL that in such sports cases where the horizontal restraints on competition are essential for the product to be available, per se rules of illegality are inapplicable, and depending upon the concerted activity in question, the rule of reason may not require detailed analysis. Rather, the rule of reason analysis can be applied in what this court refers to as the twinkling of an eye to uphold a challenged restraint. Courts commonly afford sports organizations deference and freedom to define their basic rules and guidelines. In particular,
Ms. Alexander, don't we usually use the quick look or twinkling of an eye analysis only to determine when a business practice is illegal, not to presume validity?
Your Honor, it is true that the quick look or deferential review is often used for that purpose. However, in this case, given the fact that sports organizations are generally given so much deference and freedom to define their basic rules and guidelines, and because the NCAA requires so much ample latitude, as this court has explained in Board of Regents, because of that, we believe that it will be appropriate to apply the quick look or deferential review here.
Well, how did the lower court fail to apply that presumption of validity here?
Yes, Your Honor. The lower courts here failed to apply that presumption of validity by both engaging in a very detailed rule of reason analysis and misapplying it, as my co-counsel, Mr. Studnicka, will detail. But in addition to misapplying the rule of reason analysis, they failed to afford the NCAA the deference that it is owed by failing to recognize its status as a joint venture, which also applies the rule of reason analysis with a more deferential look. Thank you, Your Honor. It is also true that this court has recognized that unless a court is confronted with a situation where the sports organization has no justification for its actions, the restraint should be upheld without a detailed rule of reason analysis. And this assertion is fully consistent with this court's proclamation in Board of Regents that the NCAA needs ample latitude.
Well, didn't the NCAA miss its misstep here being not preserving its argument with regard to the other pro-competitive effects? Right? It's basically hinging its entire argument here on the amateur nature of its sports, and it's abandoned the other pro-competitive effects that it originally asserted in this lawsuit. Doesn't that limit what we can do for the NCAA at this stage of the case?
Your Honor, respectfully, I would disagree that you are limited in what you are able to do for the NCAA in this case. I believe appropriately under the issues that we are bringing up here today, you have ample room and latitude to provide the NCAA with the request and relief that we are seeking, which is to reverse the Ninth Circuit's ruling and hold that the rule of reason analysis does not apply here. And even if it does, it was misapplied, especially given the second step, the pro-competitive nature, as you just mentioned, given the amateurism argument, as Mr. Studnicka will get into. It is also true that the other circuits outside of the Ninth Circuit, so that has been the Seventh Circuit, Fifth Circuit, and Third Circuit, have all consistently rejected the antitrust challenges to NCAA rules that preserve amateurism. These circuits have chosen to reverse or dismiss the challenges to the NCAA rules at the pleading stage without trial or a detailed rule of reason analysis. The Seventh Circuit has done this in Deppie v. NCAA and Agnew, and the Third Circuit in Smith, Fifth Circuit in McCormick. It is also true that the NCAA is a joint venture. This court has recognized that in the context of joint ventures, if a distinct product can exist only by horizontal agreement, restraints that are reasonably related to defining the product are valid and should be upheld without further analysis under the rule of reason. Here, yes, Your Honor.
The definition of amateurism seems to have changed over the course of well over 100 years. What definition are we looking at today? How can you describe to the court what exactly is amateurism? What exactly is the NCAA trying to protect here?
Your Honor, the NCAA's definition of amateurism is no pay for play as recognized in Board of Regents. Under Board of Regents, this court said that to preserve the character and quality of the NCAA's product, student athletes must not be paid and must attend school. So here we maintain that is our definition of amateurism. Students can get the full cost of attendance scholarship and the only necessary and reasonable expenses to be a student. And beyond that, the student athletes here will not be paid for play.
But at one time, Ms. Allender, those were also impermissible. The scholarship itself, as I understand it, and then also the cost of attendance, which has been in place since 2015. Have any of these impacted consumer demand?
Yes, while in O'Bannon, the student athletes did begin to receive those up to and slightly above cost of attendance payments. That was the inevitable byproduct of a rule change under the Ninth Circuit that was determined to be consistent with the NCAA's own standards of amateurism. So though there have been those increased benefits, we do believe, and it is our position, it has been the court's position, that amateurism is still maintained by those payments.
Well, isn't it a circular argument? I mean, basically what you're saying is that amateurism is whatever the NCAA says it is. So you can define amateurism in a way that arguably violates the antitrust laws, and yet we're supposed to presume its validity?
Your Honor, it is our position that amateurism is vital to the NCAA structure and to maintain collegiate athletics. And this is held true by what the Board of Regents has said, no pay for play. And we believe that there are clear limits to that. And for the foregoing reasons, I respectfully request that you reverse the Ninth Circuit's ruling and hold that the detailed rule of reason analysis should not be applied here. I turn over the balance of my time to Mr. Studnicka.
Good morning. May it please the court. My name is Anthony Studnicka, and I'm here today representing the petitioners in this matter. Today, I will be explaining why the NCAA has not committed an antitrust violation, even if it is determined that the rule of reason analysis applies. Your Honors, the argument the respondents are making cannot succeed because amateurism is an essential component that allows the NCAA to offer, allows the NCAA to offer a product which is different from professional sports. This court in Board of Regents stated that the NCAA needs ample latitude to fulfill its critical role in maintaining the revered tradition of amateurism. This ample latitude.
Mr. Studnicka, aren't you, again, if you can answer the question about what I see as the circular reasoning of your argument, amateurism is whatever the NCAA says it is, and it can define it any way it wants, which sort of begs the entire antitrust question. Don't we need some objective definition of amateurism for it to serve as your pro-competitive benefit justifying this conduct?
Amateurism is defined by the NCAA as Board of Regents recognize the NCAA has the latitude to define this. In applying the detailed rule of reason, the Ninth Circuit's analysis was critically flawed. The rule of reason contains 3 steps. The first step is not contested in this case. Under the second step, NCAA rules that are reasonably related to preserving amateurism are pro-competitive and should be upheld against antitrust law challenges. Finally, under the third step, the respondents have not sufficiently met their burden to demonstrate that amateurism is preserved under their offered alternatives. Again, the step 1 analysis in this case is uncontested, which moves us straight into step 2. Under step 2, the pro-competitive effects of the challenge rules must be demonstrated. At this step of the analysis, the Ninth Circuit inappropriately redefined amateurism by granting student athletes compensation so long as it is related to education. However,
can I ask you, has the NCAA abandoned the other pro-competitive effects it argued in the courts below, the pro-competitive effects of integrating student athletes into the school community, promoting competitive balance amongst NCAA schools, increasing the output, that is, the graduating students in the college education market? Have you abandoned those other 3 pro-competitive effects as a justification for your eligibility rules?
No, Your Honor. However, amateurism is the main justification that we are focusing on today, because this court made clear in Board of Regents that the definition of amateurism is that student athletes must not be paid, as NCAA rules have reflected for decades.
Don't current NCAA rules actually allow for precisely the kind of cash payments that you're claiming O'Bannon has rejected?
No, Your Honor. The NCAA's conception of amateurism is not refusing 1 penny over the cost of attendance. The NCAA's conception is instead that student athletes cannot be paid for athletic play, but can receive legitimate coverage of expenses and modest awards related to education. Extending this standard, as the Ninth Circuit has, to anything related to educational benefits is dangerously extending this scope, which may similarly reflect professional salaries and thus blur lines between professional and college sports.
What about performance awards, cash awards that are given to your college athletes? How are they tethered to education?
The NCAA rules have been modified to update the decision in O'Bannon, and since then, the NCAA has complied with the Supreme Court's holding in O'Bannon to modify their rules in accordance with that decision.
I want to ask too, Mr. Stanica, about what Judge Balsam is I think going towards is, what I see is this shifting sands of amateurism and these extra benefits that the Ninth Circuit allowed through cost of attendance, as I see it, has not had any pro-competitive negative effect on the product. So does it stand to reason that any other additional income, or however it's couched, educationally tethered or straight pay, doesn't it stand to reason, pun intended, I guess, that people will still come to watch the games?
Your Honor, the challenge rules are valid because they have pro-competitive effects, and no alternative would similarly preserve amateurism and the distinction between college and professional sports. Preserving these principles is what makes college sports unique. Dr. Bruce Isaacson, a marketing consumer behavior expert, testified that 1/3 of college sports fans surveyed reported that they like college sports because their players are amateurs and or not being paid. Because the NCAA showed that the challenge rules have pro-competitive benefits, the respondents had the ultimate burden to show that the rules are unreasonable because those benefits could be achieved through a substantially less restrictive alternative. The respondents failed to do so. The Ninth Circuit decision incorrectly applies a rule of reason analysis, and the Ninth Circuit decision redefined amateurism and denied the NCAA the latitude this court has already granted. We ask your honors to respectfully reverse the Ninth Circuit's holding. Thank you for your consideration, and I would like to reserve the remainder of my time for rebuttal.
Great, thank you. And Lauren, Elizabeth, who will be responding first?
I will be speaking first.
Great. Yeah. And All right, Lauren, timer is ready. Whenever you start, I will start the timer.
Good afternoon, Your Honors, and may it please the court. My name is Lauren Johnson, and I, along with my co-counsel, Ms. Elizabeth Gardner, am representing the respondents in today's case. As opposing counsel noted, there are two issues before this court. I will be addressing the application of the deferential review, which has also been called the quick look, and my co-counsel will be addressing the NCAA's violations of antitrust law. This court should affirm the Ninth Circuit and rule that the lower courts correctly used the detailed rule of reason analysis instead of a deferential review for two reasons. First, the language in the NCAA versus Board of Regents case is dicta and does not support the idea of a deferential review. And second, the NCAA relies on amateurism for its justification of a deferential review, but the NCAA doesn't have a consistent definition of amateurism.
Is it your opinion, counsel, that we should not use dicta as anything with regards to this case?
Your Honor, there is certainly some persuasive dicta in this case, but it is our position that it was not the holding in the case and is therefore is not binding on this court. And while the dicta has acknowledged that amateurism can be a pro-competitive justification, it did not give the NCAA the ability to completely prohibit all challenges to its rules.
Counselor, the Supreme Court, however, instructed the courts below, our court instructed the courts below that we have to afford the NCAA ample latitude to superintend college athletics. How ample is that latitude then? Even granted that it might be dicta, what is the degree of latitude that we should be affording the NCAA here?
Your Honor, it's our position that the NCAA has already been awarded that ample latitude that the Board of Regents references. Normally, horizontal restraints on a market like the ones the NCAA has are considered illegal per se and forbidden by the Sherman Act. But instead, the Board of Regents Court recognized that these restraints are required to produce college sports and therefore evaluates them under the rule of reason. Thus, the NCAA has already received any deferential review that the Board of Regents case might stand for. And anything beyond that would simply be blanket antitrust immunity from any student-athlete antitrust cases.
So are there any NCAA rules entitled to quick look treatment and presumed legal? Can you come up with an NCAA rule that the court should presume legal and dismiss pleadings at the earliest stage?
Yes, Your Honor. So one of the essential differences is that they are not as professional athletes, and the lower court has upheld that difference. So, for example, if a student athlete wanted to play for a school and be on a practice team for an NFL football team, that would clearly violate the amateurism rule. And that's the type of differences that the NCAA is able to implement and would be entitled to be dismissed in the pleading stages. However, the NCAA is arguing today that students don't deserve educational benefits like study abroad expenses or science instruments simply because that crosses the line to from amateurism to professionalism, and that's simply not the case. And we cannot give the NCAA this blanket antitrust immunity. Even Congress has recognized that professional sports athletes have standing to sue under antitrust lawsuits that are part of professional sports organizations.
So what you're suggesting is that, if we uphold the ruling of the court below here, then the NCAA could continue to be challenged every time it re-regulates. So unless, as of the time our decision comes down, it freezes its regulatory apparatus for all time, every new regulation shy of the one that you say should be presumed valid could be challenged, and they'll be back in district court repeatedly for a full-blown rule of reason analysis of every form of regulation. How is that something we ought to endorse?
Your Honor, that would not be the case, because this previous lawsuits and this lawsuit have set forth these boundaries for what can be challenged. And right now, we're talking about educational payments to athletes, and the O'Bannon case is being paid for name, image, and likeness rights. Certain eligibility rules like, can you transfer schools and play immediately? Those are not in question today, and those would be valid under the rule of reason. The other thing is, Your Honor, is that the NCAA should have to defend its rules in court. If they're not valid rules, they shouldn't get to say that these are eligibility rules and simply get to essentially run college athletes without any input.
But counsel, they're saying that people will not watch the games, that the industry itself will fall if they're not allowed to apply these rules and keep whatever definition of amateurism it may be. How do you respond?
Your Honor, you make an excellent point, and that ties into the second part of my argument. As these justices noted earlier, the NCAA's definition of amateurism is inconsistent, and it has not impacted consumer viewership in the past years. In the past decade, the rules have changed. Athletes can get full cost of attendance scholarships. And in fact, the University of Nebraska can pay their graduate students $750,000 in order for graduate programs. And that has not impacted any of the University of Nebraska's viewership since they started doing this. If you ask any fans that are in Indianapolis today watching March Madness, they'll tell you they don't care whether or not athletes are paid or receive nominal couple $1,000s for their participation on these teams. They care about watching the team because they went to that school and they love the sport.
Ms. Johnson, aren't we just talking semantics here? The difference between, giving someone money for graduate school or giving someone money to go on an NFL team. And isn't the NCAA in a better position to define that?
Your Honors, no. If anything, it's the conferences and the schools themselves that should have the ability to manage that. Right now, the NCAA has laid down the law that these conferences can't pay these extra, study abroad expenses, stipends for internships. And what the injunction from the district court does will allow the conferences and the schools themselves to control that decision instead of the NCAA. We asked this court.
Counsel, I went to I guess what is defined as a mid-major school. I'm not going to have a competitive team to cheer for, it sounds like, if we go down this route you're talking about.
Your Honor, respectfully, I disagree. This simply allows colleges who have the extra money to offer these benefits if they want. It doesn't require them to. And these benefits are not going to be significant enough to truly change the landscape of college recruiting. I am going to go ahead and yield the remainder of my time to my co-counsel, Ms. Gardner. Thank you.
Good afternoon, Your Honors. May it please the court. As my co-counsel stated, my name is Elizabeth Gardner, and I also represent the respondent in this case, Sean Alston. We ask this court to affirm the Ninth Circuit and find that the NCAA's eligibility rules violate federal antitrust laws when analyzed under the rule of reason. These student athletes are entitled to better educational benefits than what the NCAA has deemed that they deserve. The NCAA has essentially asked this court for an antitrust exemption to prevent student athletes from receiving financial assistance that would go to covering education-related benefits such as study abroad fees, science equipment, and internship assistance.
Counselor, I just want to clarify, you've abandoned the claim below that college athletes should be, that the NCAA should not impose any restrictions on compensating college athletes?
Your Honor, we are asking this court to affirm the education-related benefit, we're asking this court to find that the NCAA's rules regarding the education-related benefits do violate antitrust laws. So the lower courts did find that the other rules that were challenged did have pro-competitive justifications, and there are offered alternatives by the student athletes at the lower court that do allow the NCAA to cap certain awards and the certain benefits. However, we are asking this court to affirm the allowance of education-related benefits for student athletes.
Counsel, what would prevent me from saying I want to buy a Cadillac for an athlete because that gets him or her to school and that's educationally related?
Your Honor, the NCAA will still have the latitude to define what education-related is, and while I don't represent the NCAA, I can imagine that they will not allow, particularly buying Cadillacs for transportation costs, to be deemed related to education. Really what student athletes are asking for are things that will further their education.
And so when the NCAA regulates those, that issue, what is tethered or to education, what furthers education, if they cross a line in the minds of some antitrust plaintiffs counsel, they're going to be back in court defending their new set of regulations. How do we cut that short? How do we allow the NCAA to operate without spending time, energy, resources defending antitrust claims in full-blown rule of reason cases?
Your Honor, there is a clear line between paying student athletes for playing sports and these education-related benefits. The NCAA does serve a role in being in overseeing intercollegiate sports. They will have the latitude to define education-related benefits, and as evidenced by this litigation, that education-related benefit will need to be directly tied likely to the student athlete's major and will be determined according to that conference's limits and according to the NCAA's rules that they should promulgate after this litigation. However, the NCAA does not receive blanket immunity from antitrust law simply for being the NCAA. It is within their realm to create rules that create bright line demarcations of what's appropriate and what's not appropriate. And they should not be completely immune from antitrust laws because, frankly, the NCAA and the colleges and the coaches make money off of the labor of student athletes, while the NCAA is allowed to artificially cap and devalue that labor. Under the rule of reason analysis, the Ninth Circuit properly found that these eligibility rules violate federal antitrust laws. The NCAA conceded that under step 1, the plaintiffs met their burden of showing an anti-competitive effect of these rules in the relevant market. But I'd like to explain exactly what the NCAA conceded here. In the market where student athletes exchanged their labor and their hard work for a college education and a spot on the sports team, the NCAA has artificially capped and limited the value that they can receive in exchange for that, much lower than what it's actually worth. Regardless of the compensation offered, a competitive student athlete will choose to attend a college.
So we understand that the issue of the anti-competitive effects has been conceded by the NCAA, but in terms of their pro-competitive benefits that arguably outweigh that anti-competitive effect, is it fair for us to look at the pro-competitive benefits outside of the market for recruiting high school students? Where should we draw the line at the second stage of the rule of reasons in terms of examining pro-competitive benefits?
Your Honor, the line should be drawn at the definition that the lower courts used for amateurism. As Your Honor pointed out to opposing counsel, the NCAA has used a very circular definition of amateurism. Sometimes it's being completely unpaid, but that really discounts what the NCAA does allow compensation for. As Your Honor pointed out, student athletes can receive cash achievement awards as well as things like gift cards, Visa gift cards with cash values attached to them. So the NCAA telling this court that amateurism means that athletes are unpaid is simply untrue when looking at the NCAA's actual rule scheme.
Well, didn't the court below, though, fail to assess the NCAA rules in their totality as to whether they're pro-competitive? I mean, the way I see the bench trial's outcome is that the court there evaluated each and every rule singly and independently and did not consider them as a whole as to whether they collectively and in their totality achieved adequate pro-competitive benefits.
No, Your Honor, the lower court properly looked at each of these rules and in fact upheld most of them as having this pro-competitive justification of preserving amateurism. However, the capped education-related benefits did not meet this did not preserve amateurism and create that difference between college sports and professional sports. And the alternatives offered by the student athletes at the lower court do still serve the same pro-competitive purpose of preserving amateurism while being a less restrictive restraint on the market for college athlete labor. These student athletes provided survey evidence that seven different proposed education-related benefits would have no effect on consumer demand. And as Judge Ridpath asked opposing counsel about, there has been no change in consumer demand since the O'Bannon decision that allowed for paying the full cost and attendance of student athletes. In conclusion, Your Honors, we ask this court to affirm the Ninth Circuit and find that the NCAA's eligibility rules violate federal antitrust laws. It's time for student athletes to receive a piece of the pie, and this is the best way to do that. Thank you.
I think that you're muted, Casey, but if you're asking who's doing rebuttal, it's me.
Yes, thank you.
No problem.
Okay. 2-minute rebuttal. We'll start it on your go.
Thank you. Your Honors, as you've mentioned today, under the lower court's inappropriate redefinition of amateurism, student athletes would purportedly still be amateurs even while being paid large sums, as long as those large sums were not unlimited amounts unrelated to education, akin to salaries seen in professional sports. This redefinition is erroneous for 2 reasons. First, antitrust law does not empower courts to redefine key features of a joint venture's pro-competitive products. Second, the redefinition of amateurism contradicts Board of Regents, which recognize that the difference between college and professional sports is that student athletes are not paid to play, which is the very definition of the NCAA product. Further, Your Honors, respondents have argued here today that the NCAA seeks an antitrust exemption or immunity. That is incorrect. The NCAA is not arguing that it engages in anti-competitive behavior that cannot be redressed through the antitrust laws. That would be antitrust immunity. The NCAA, rather, is arguing that its eligibility rules are so clearly pro-competitive that the rules' lawfulness under the antitrust laws can and should be determined early on in the litigation process.
Now, so I'm going to ask you a question that's sort of the flip side of what I asked your adversaries, which is, can you identify for me a rule the NCAA might promulgate that would not be entitled to quick look presumed validity, that would necessitate a full-blown rule of reason analysis?
Yes, Your Honor. So if the rules that are promulgated by the NCAA are not clearly pro-competitive, they would be subject to a more detailed rule of reason analysis. So different from amateurism, if for some reason the NCAA had created a rule that was not pro-competitive, it would be invalidated or be possible to be invalidated under a rule of reason analysis.
Could you give an example there for us, please?
Your Honor, I have not thought of candidly a situation that would be so far-reaching as to be completely against any pro-competitive benefits, but I would be happy to submit a supplemental brief with examples of these made-up, I guess, rules that would be anti-competitive.
Does everything have to have a cap, or do you guys prefer, a rule without a cap in regards to payment?
With regards to payment, we would like it to be what the rule is currently, such that the NCAA can allow the student athletes to not be paid for their paid for playing, but it would not be a cap on the rule. Your Honors, this court's precedent and the lower court's ruling should be reversed, because this court's precedent holds that rules reasonably related to defining the distinct product that is pro-competitive, like amateurism does, should be upheld without a trial or full rule of reason scrutiny. This court should therefore reverse the Ninth Circuit's judgment and remand with directions that judgment be entered in favor of the NCAA on all respondents' claims. Oh, thank you.
Casey, you're muted.
Thank you, Jody. Everyone did a great job. Thank you so much, everyone. Fantastic job by both sides. Jada, Anthony, Lauren, Elizabeth, you guys did an incredible job. Judges, thank you so much. Those are great questions. I really appreciate the detail that you guys put into this and the thought-provoking questions. Incredible job. I would open the floor if anyone, if the judges want to provide feedback, constructive, positive feedback, since we are live streaming. That would be great.
All I can say is, wow. I can't believe you mastered this in 2 weeks. I've been teaching the NCAA litigation in my sports law class for 6-7 years now since it started. I have to tell you that each and every time I get to the college sports antitrust unit of my class, I have to sit down, I have to reread the cases, I have to figure out what really went on and how to communicate it effectively to students. And that you did this in 2 weeks without necessarily having taken an antitrust course, I was an antitrust practitioner for years, and this case is really challenging. So bravo.
Yeah, I agree. I just wanted to say that I wish it was you four that we're arguing here in a couple weeks, because I think you do a fantastic job. So I was very impressed. Like Jody said, and I'm not an attorney. I've spent a lot of time in courtrooms, and I know this case pretty well, and I was blown away by your knowledge of it. For me, this may be kind of a strange question, but just for fun, what do you really think, each of you? If you tell me, which side would you come on and want to defend if you actually had to defend it here in a few weeks in front of SCOTUS?
I will say that I, in the previous round, represented Alston, so I've now done both sides, and I do think, in my personal opinion, having given the arguments, that Alston has the easier argument to make. I think Jody's questions, or I guess Judge Balsam's question.
Jody's fine.
She's Jody now. Yeah.
Jody now. Either that or Your Honor is fine.
Yeah, Your Honor's questions related to amateurism. It's a great point, and I think candidly, Alston has a strong argument, having just given that exact argument yesterday.
Yeah, I would definitely just echo exactly what Jada said. After being on both sides of this, definitely found a lot more difficulty preparing for this argument. And the questions that we dealt with on this side of the argument were a lot harder to defend than I feel like in Alston. Alston, it kind of flows together quite naturally. And in the NCAA side, it's very antiquated and it's very narrow and it's very specific, and arguing that is difficult.
Well, I think Anthony, I want Lauren and Elizabeth to talk, but I always just say when I talk to, and I don't teach sports law, but I do governance debates. I teach sports ethics and governance. And I always tell my students, you've got to know each side. You may be passionate about one side. If you're passionate against paying college athletes, you got to understand what the side is for. And I think that's what I like this exercise. And you do understand both sides, and it's good to see both sides. So we'll hear from Lauren and Elizabeth now. Sorry.
I think that the NCAA definitely has more case law in support, but Alston has the best public policy argument in that they're essentially going to get immunity from all of its cases. So, and as a fan of college sports, I'm more on the student athlete side, but I mean, I see it equally from both ways.
Okay.
I'm going to go ahead and agree with everybody. I think the student athletes really have a strong argument here. Particularly the public policy side. And I think the reality is that, the lower court did things right and the student athletes still came out on top. So we'll see how it goes.
I wonder with Jody and Zach, how do you think this court is going to rule, though, with the justices we have?
I was just going to say, it's really hard to read the Supreme Court tea leaves, but why would they take this case? Why would they grant cert here when they could have left the Ninth Circuit alone? They could have let the decision stand. So I actually have a theory. It's a sort of an antitrust nerds theory, which is that the reason that they took the case has nothing to do with how they feel about the NCAA or public policy over college athletics. It's because they think the Ninth Circuit got the rule of reason framework wrong, and that it's of concern to every industry and joint ventures in all industries, that the Ninth Circuit, the largest circuit in this country, is misconstruing and misapplying the rule of reason. And they're going to tinker with that. And by the way, they haven't really restated the rule of reason in a comprehensive way except for the recent American Express case, in decades. And in the recent American Express case, they restated the rule of reason in its sort of black letter form, but without actually applying it, because that case was decided at a very early stage of the analysis. So I think this is going to be an opportunity to satisfy all the antitrust nerds out there as to what the rule of reason requires. And it's going to go back to the Ninth Circuit, back to the district court on remand to reapply the now properly articulated rule of reason to the facts in that case. So that's my prediction, and it has really nothing to do with college sports.
Yeah, interesting.
Yeah, that's wild. Yeah. I want to say everyone did a great job. As I'm a little biased in a way, just being, sort of on the Alston side. So I think, I agree with you. It's sort of an easier argument to make, but you guys did a great job. As our job as judges are to ask you tough questions and try to trick you. And it was, pretty, it was a pretty good job. We couldn't do that. So everyone did a great job. And I just want to say, for the limited time you had, it was really impressive.
Awesome. Well, thank you so much, judges and students. You guys did an incredible job, everyone. Jody, I also appreciate your analysis and why you think that they picked it up. I haven't heard that, so I hope you're right. I'm also on pins and needles, waiting to see how it comes out, especially with the makeup of our new Supreme Court and how you could argue that it's a very conservative court at the time. So very, very interesting. Can't wait to see what happens. Thank you all so much. Judges, if you can, please, in the next 20-30 minutes, please send me the score sheets so I can tally it up and let the law students know, because the winner has to move on and argue again tomorrow in the finals. So that is all. Thank you all so much. It has been absolutely wonderful.
Thanks for
Good
having
luck,
us.
everyone.
Yeah, good luck. Really appreciate it.
Yeah, likewise. All my best, guys. Great job.
Thank you.
Thank you.
Thank you all.
Go Bobcats, by the way.
Go Orange. Go Orange.
Oh, yeah, that's right. They did win. So, all right.
Major
Bye-bye.
upset.
Kill.
I love it.
So much.
Yeah. Welcome everyone back to No Cap Sports Moot Court Madness. It is fantastic to have everyone here. Thank you so much. The law students coming back for the second day. They did an amazing job yesterday, and I'm so pleased to have Tracy, Len, and Luke all here judging us. Fantastic to have everyone. What I'm going to go ahead and do is I'm going to do an introduction of the judges, and then I'm going to kick it off to the law students to introduce themselves before we get going. And we'll start. Len Simon is a lawyer in San Diego and an adjunct professor of sports and the law at the University of San Diego. His practice involves a variety of complex litigation with a subspecialty in sports-related cases. He has represented Major League Baseball, the San Diego Padres, athletes, agents, sporting goods manufacturers, and others. He has also taught at Duke and USC. Professor Simon publishes articles on sports-related and some other topics in the Sports Business Journal and various major newspapers. He graduated from Duke Law School in 1973, clerked for a federal district judge, and worked for a large firm in Washington, D.C. before moving to San Diego and joining what is now called Robbins, Geller, Rudman, and Dow. Thanks for joining us, Len. Tracy Bransford is a partner at the Minneapolis office of Stinson LLP, where she serves as the co-chair of Stinson's Entertainment and Media Law Group. She focuses her practice on counseling media and communications clients on legal issues related to the entertainment industry, and is a member of the Intellectual Property and Technology Division at Stinson. Tracy also serves as general counsel to professional and retired athletes in their individual business and philanthropic pursuits. She works closely with Stinson's charitable planning professionals to coordinate the implementation of her athletes' charitable planning. She is an active member of several charitable and professional organizations and is a sought-out speaker on entertainment law, sports law, and celebrity philanthropy and diversity. Thank you for being here, Tracy. Luke Fedlam is a partner in Porter, Wright, Morris, and Arthur LLP's corporate department, leading the sports law practice group. Working with an athlete team of advisors, he provides the essential, objective, thorough, and balanced counsel necessary to leverage the opportunity at hand. Luke regularly advises a range of clients, from student athletes transitioning into professional sports and professional athletes navigating life on a team, to retiring athletes creating the game plan for their life after sports on matters including marketing, contract analysis, immigration issues, investment opportunities, due diligence, asset protection, real estate development, brand and mark protection, as well as trust and estates. Thank you, Luke. It is fantastic to have everyone here. I'm so excited about our judges and these two phenomenal teams. And I just want to point out to everyone that these two teams have digested this information and argued in moot court in under 2 weeks. And they have their law school classes going on at the same time. It is an incredible feat, and all the credit really goes to them. I'm going to start with Jalen, the alternate for Notre Dame, and then continue through Notre Dame before Harvard, so everyone has a chance to give some introductions.
Good afternoon, Jalen Amaker, 2L at Notre Dame Law, here as an alternate / player coach. Grateful to be here. Thank you all for taking the time.
Great.
Hi, my name is Paige Carey. I'm a 2L at Notre Dame Law School and very much looking forward to the competition today. Thank you again for NoCap for hosting this for us.
Hi, good afternoon. I'm Danielle Lynn, also a 2L at Notre Dame. Very thankful to NoCap Sports for putting this on. It's been an amazing experience and excited to argue again today.
Oh, sorry, muted, Ellie.
That's my mistake. Thank you, Casey, and thank you to NoCap Sports for having us here today. My name is Ellie Nachmani. I'm a second-year law student at Harvard Law School and the incoming co-editor-in-chief of the Harvard Journal of Sports and Entertainment Law. Cannot wait for today and really looking forward to it.
Hi, everyone. My name is Kit Matwire. I'm also a 2L at Harvard Law. Very excited to be here. It's been a blast so far, and I hope everybody's remaining safe during the pandemic. And thanks again for allowing us to continue with this.
Thank you all for participating. This is an incredible event. Danielle, Jalen, Paige, and Dean Edmonds, their advisor, Ellie, Kit, and their advisor, Peter Carfagna. And then our judges, Len Simon, Luke Fedlam, and Tracy Bransford. Thank you all. I'm going to go ahead and give a brief background on an aspect of the case that I think confuses a lot of people, and I want to make sure that I can clear it up for everyone at home. And that'll lead in perfectly to the case at hand and where it stands today. So the Alston case is actually very different than O'Bannon, which was limited to name, image, and likeness, because Alston was originally challenging the entire array of NCAA amateurism-based compensation limits. The student athletes originally alleged that the NCAA and 11 athletic conferences violated antitrust law by fixing the price of scholarships and other benefits. And Alston was originally arguing to create a free market back in 2014 when they actually started this case. The district court found for the athletes, holding that the NCAA must allow for certain types of academic benefits, such as computers, science equipment, musical instruments, and other tangible benefits that aren't included in cost of attendance, but related to academics. But why was the holding about education-related benefits when Alston was originally filed to challenge the amateurism model as a whole and attempt to create a free market? Well, this actually takes me back to law school. You see, the district court was bound by the O'Bannon 2 decision which prohibited an open market for the student-athlete services. And the remedy from the court was limited to education-related benefits. So to be clear, basically the O'Bannon 2 decision created an education limitation. So if Alston actually wanted a free market, they would have to argue that O'Bannon 2 was wrongly decided at the remedies phase. This is very confusing, and Justice Thomas explains it very well in his dissent of O'Bannon 2, and I'm just going to paraphrase the justice here for everyone so I can clear this up. The majority in that case looked at whether allowing athletes to be paid name, image, likeness compensation unrelated to education is virtually as effective in preserving amateurism. Justice Thomas said the court should have looked at whether allowing athletes to be compensated for their name, image, likeness is virtually as effective in preserving popular demand for college sports. So essentially, the antitrust analysis is about whether it should be about the concept of preserving amateurism or preserving consumer demand, with amateurism only being relevant as it relates to consumer demand. Since the majority in O'Bannon 2 looked at preserving amateurism, it provided a form of antitrust immunity to the NCAA because it foreclosed the free market argument and limited the judgment to education benefits. And that is where we find the Alston case today. Thank you so much, everyone. I'm excited to get this going. I will say, so we have Notre Dame as the petitioner arguing for the NCAA, and who will be leading us off? Danielle, fantastic. Let me. Great. Awesome. So judges, I'll just remind you, you can ask questions at any point except for the final minute. And I will put up a banner that lets you know when the 1 minute is on so they can just finish their thoughts. Otherwise, I will provide a 5-minute warning for our participants. And Danielle, whenever you are ready, I will start the timer.
Great, thank you. Good afternoon, and may it please the court. My name is Danielle Lynn, and I, alongside my co-counsel, Paige Carey, represent the NCAA in this matter. With the court's permission, petitioners would like to reserve 2 minutes for rebuttal.
Granted.
Thank you. The Ninth Circuit erred in using a detailed rule of reason analysis for 2 reasons. First, the Ninth Circuit dismissed language from this court that has informed the analysis and federal review of NCAA cases for 3 decades. Secondly, the NCAA's status as a joint venture entity allows for deferential review. The Ninth Circuit ignored this practice. Your Honors, at the outset, it is important to note the petitioners are not asking the court to come up with new innovations. They're not asking the court for an exemption. They are not asking the court to change the landscape of antitrust law or the NCAA for that matter. Rather, petitioners are simply asking that the Ninth Circuit be held to the standard outlined by this court and uniformly applied throughout the federal judiciary for the past 3 decades.
Counsel, I believe you're referring to the Regents case. Would that be correct?
That is correct, Your Honor.
Counsel, wouldn't you agree with me that that's about as pure dicta as we see in the courts? It's a 40-year-old case, and it is about television rights. And it seems to me that it's the least precedential thing that the court said in that case. How can that bind courts 40 years later when, contrary to what you said about unanimity, the circuits seem split? To me, the Seventh Circuit sees it one way and the Ninth Circuit sees it another.
Sure, Your Honor. So Board of Regents is distinguishable on the facts. Of course, the court was considering 2 separate issues here. However, in Board of Regents, this court went on a detailed analysis of amateurism and on the pro-competitive end that the NCAA seeks to uphold, and whether or not that language in Board of Regents was held as a matter of law. the fact remains that across the board, except for the Ninth Circuit, the entire federal judiciary has used that standard and has upheld that standard.
Well, you mentioned amateurism in your argument. Is amateurism really needed to have a differentiated product from professional sports?
Yes, Your Honor, the petitioners believe that it is. And the definition of amateurism that we're looking at is that athletes cannot be paid, student athletes cannot be paid for their athletic achievements. So that's the clear line of demarcation between the NCAA's product and other professional sports product. So the petitioner's position is that it is extremely relevant here.
Counsel, I don't see a clear line anywhere. The athletes can earn cash prizes, even before O'Bannon, before Alston, cash prizes, awards when they go to bowl games, when they go to the Final Four. It seems like it's kind of amateurism is whatever the NCAA says it is that year. Is that something that the court should defer to?
Well, Your Honor, respectfully, I would disagree with that perception of amateurism. The NCAA's position is that amateurism is tied to not paying for athletic abilities. So what you're referring to goes to the cost of attendance and what's reasonable through Congress to be allowed in the cost of attendance.
No, getting a prize for playing in the Rose Bowl, I don't think is cost of attendance. I think, and no other athlete on campus gets it. Cheerleaders don't get it, just the football players.
Right, Your Honor. If I would turn your attention to page 8 of the petitioner's brief, where we outline what the cost of attendance is and how it plays into the athletic basically rewards that the NCAA permits. And how it plays in there is that we know that cost of attendance allows for the fixed costs that the court and the parties are well aware of, but it goes beyond that. And it also allows for miscellaneous expenses that can be reasonably attributed to academics. The NCAA's position is that because institutions set the cost of attendance, because they can switch the cost of attendance on a case-by-case basis, it is reasonable that they can allow sort of these shifts in prices based on the athlete.
Thank you.
Yeah, sure. So to my first point, the court established in Board of Regents that the preservation of the student athlete in higher education is entirely consistent with the goals of the Sherman Act. This court and Board of Regents agreed with the petitioners that in order to preserve the character and quality of the college sports, athletes cannot be paid. Every federal challenge to NCAA compensation rules in the last 37 years has been properly measured against the standard this court put forth in Board of Regents.
But Counselor, wouldn't you say though that over the past 37 years, a lot has changed in the college sports space, and that therefore a more detailed analysis would be appropriate so that we could better understand the economics and how the NCAA, is in the middle of March Madness, a $20 billion contract, but yet, to my esteemed colleague mentioned, a little goodie bag that comes at the Rose Bowl, I don't think aligns with the growth that we've seen over the last 37 years. So shouldn't a more detailed analysis be used?
Respectfully, Your Honor, I would disagree. And I would also argue before the court that it is exactly the timing differences between when these cases were decided that helps the petitioner's argument. It shows that this rule has existed throughout time, no matter what the NCAA looks like, so long as it is advancing the role of amateurism, that college athletes do not get paid to play, then courts have upheld this rule and they should uphold this rule.
But the NCAA changes the amateurism rules as often as Walmart changes their prices. I mean, Counsel, I'm not sure if you know this, but there used to be a rule against full scholarships. That was considered to destroy your amateurism decades ago. Could the NCAA, in its wisdom at its next meeting, decide no scholarships can be awarded, no athletic scholarships can be awarded, or half athletic scholarships are a maximum? And when somebody brought suit under the antitrust laws and said that the Duke should be able to make its own decision and Michigan State and Ohio different decisions, your position would be that the courts should defer to the NCAA's wisdom in going back to that old rule? They call it amateurism every decade.
Yes, Your Honor. Well, the petitioner's position is that as long as the rule has a limit that provides the clear line of demarcation between the unlimited benefits of professional athletes and the limited benefits of the NCAA's athletes, then that does advance amateurism. So the shifts that you're speaking about through time have all been tethered to a specific line. Now, Your Honors, I see that my time is running out. I would like to save some time for rebuttal. Unless you have any other questions, I will defer to my co-counsel, Paige Carey.
May it please the court. I, Paige Carey, along with my co-counsel, Danielle Lynn, represent the petitioners, a member-led organization dedicated to the well-being and lifelong success of college athletes. The NCAA eligibility rules regarding compensation of student athletes does not violate federal antitrust law. Change does have to happen in college athletics, but this change is happening in Congress, which we fully support. Our amateurism model has shifted because change is necessary. The NCAA does not aim to become the next Blockbuster. But the change implicated by the Ninth Circuit here is not a positive change. It will effectively rid the nation of college athletics as we know it for two main reasons. First, the
Counsel, I'd like to hear those main reasons, but I have to ask, just because the premise of your argument here is that the change of money into sports is automatically going to just potentially render, college sports, extinct. We've got examples of college coaches making millions and millions of dollars. Their financial compensation has increased dramatically over the last, number of decades. We've seen more and more money in sports for everyone except for the athletes. So why is it that if the athletes earn money not paid for by the NCAA, but having the opportunity to do it on their own, why would that render the NCAA extinct?
Your Honor, that question actually goes straight to my first point, which is that the Ninth Circuit ruling would open the floodgates to antitrust litigation against the NCAA, other sports leagues, and joint ventures more generally. Every decision we make with the rule of reason analysis is subject to litigation, and there is a slew of cases lined up behind this case. And for the NCAA, after the floodgates open, there would truly be no difference between college and professional sports. And part of the NCAA's job is to safeguard against this. For other joint ventures more generally, the least restrictive test the court selected puts the court in an awkward position of routinely second-guessing business decisions. And Chicago Professional Sports Limited Partnership versus the NBA tells us that antitrust laws do not deputize district judges as one-man regulatory agencies. The NCAA is in the best position to draw the necessary line of demarcation of compensation for student athletes.
But counsel, excuse me, I'm sorry to interrupt you, but why might they not be in the worst position, or why might they not be doing their job right? You're making an argument that applies equally well to a perfect NCAA, to an NCAA riddled with inconsistencies and self-dealing. And I just wonder if we want to give that much authority to this organization or to the next organization that comes down the pike if you win this case and they say, well, we win, read the Alston case, and you'll see that.
Your Honor, the NCAA already provides the legitimate expenses necessary. This has been consistent with the long-standing concept of amateurism that student athletes can receive legitimate educational expenses and modest achievement awards. And if we keep moving the mark, inevitably no one will be happy. The permissible natural experiments mentioned by the Ninth Circuit did not change demand because they were in alignment with the principle of amateurism. These allowances are consistent with amateurism, and therefore their adoption would not be expected to diminish consumer demand.
Excuse me, counsel. With regard to that, would impending state legislation around name, image, and likeness laws completely invalidate the NCAA's amateurism argument?
No, Your Honor, and the issues are distinct between the name, image, and likeness going through Congress right now and also with the Alston decision. The court here is analyzing the rules that the NCAA creates in respect to student athlete compensation, whether it is monetary or whether it is a item. And the O'Bannon Court affirmed the NCAA definition of amateurism already, even though the NCAA rules allowed student athletes receiving financial aid above the cost of attendance through Pell Grants and the SAF fund and the AEF fund. Additionally, there has been no finding that any of the NCAA's challenged rules had a substantial anti-competitive effect, and this is similar to the American Express case, where an anti-steering provision was not considered anti-competitive. With respect to my second point, the court below converted college athletics into poorly paid or not poorly paid professional athletes, running counter to the holding in Board of Regents. The pro-competitive—
Excuse me, counsel, how could it not have any anti-competitive effect? If my son is the best high school basketball player in the United States and he shops for the best deal, he's offered the best deal everywhere, right? Harvard, Notre Dame, UCLA, everywhere they say full scholarship plus a few little things. And he says, I'm the next LeBron James. I want more. They say, sorry, the NCAA has told us not to compete. How is that not anti-competitive?
Your Honor, the NCAA, I see I am running out of time, but I would like the opportunity to answer your question briefly. The NCAA allows cost of attendance based on university cost, and university cost varies within different institutions. And for these reasons, we respectfully ask the court to overturn the Ninth Circuit ruling. Thank you.
Great. Thank you, Notre Dame. And then Ellie, who will be leading you guys off? Great.
Thank you, Casey. Your honors, and may it please the court. My name is Ellie Nachmani, and along with my terrific co-counsel, Kit Matoyer, I will be arguing for the respondents Alston et al. In this case. I'll be taking the first question. She will be taking the second one. Now, using the quick look doctrine to uphold the restraints of trade at issue in this case would betray the court's long-standing approach to antitrust scrutiny, both as a general matter and in the context of sports law. The Ninth Circuit was right to affirm the district court on this issue, and we urge that this court do the same for three reasons. First, the NCAA's request for abbreviated deference in cases like this one is an extraordinary ask of this court, generally unsupported by the case law and imprudent as a functional matter. What courts have called the quick look doctrine is a method of antitrust scrutiny usually reserved for invalidation of unlawful restraints of trade, not approval of them. Second, to the extent that courts see fit to accord some measure of judicial restraint in antitrust challenges to sports leagues and other joint ventures, such restraint applies in particular circumstances, the likes of which are not before the court in this case. The NCAA engages in a bait and switch, describing the classic rationale for antitrust deference to sports leagues on a certain class of restraints, then quickly argues for application of the deference to a different type of restraint. The court should reject this gambit. Third and finally, the NCAA misinterprets the language of Board of Regents, and in so doing, it cherry picks lines from a case it ultimately lost, and wrongly cites dicta as applicable authority here. The court should decline the NCAA's invitation to reread Board of Regents in a manner more favorable to the association, particularly given the issues then before the court.
Mr.
Excuse me,
Nachmani.
counsel. Oh, go ahead. No, please.
Sure. Mr. Nachmani, the problem I have with what you're saying is the number of issues that were tried under the rule of reason in this case. Although our moderator has correctly described how the O'Bannon case started and how the Alston case started, it didn't end that way. They ended essentially in a trial of dozens of different actual or potential or suggested limitations on athlete compensation, and experts opining one way or the other, and counsel opining, and the counsel having to decide if each one was necessary and appropriate. That's not how antitrust cases usually operate. They usually involve one issue. Are we going to have multi-week trials once a year or every 3 years over the NCAA rules, over every jot and tittle, as they say, of the rules?
Well, Your Honor, the response here is that we're just trying to vindicate our rights under the Sherman Act, the antitrust laws. And so Congress knows well if it has an issue with this, and I think this is a question for Congress if it wants.
The antitrust laws were written in I think, several decades ago in Teddy Roosevelt's age. They're two or three sentences long. All this is worked out in case law, and you're talking about a rule of reason that's not statutory, a quick look's not statutory. It's all judge-made law. We can make it. And the question is whether you can come into court and say, the NCAA stinks. I want to try everything they do. And you can get a jury trial costing both sides millions and millions of dollars over your theory that the athletes should get more money.
Well, Your Honor, I would dispute the characterization that it would only take putting the NCAA stinks in a brief to survive a motion for summary judgment. I think, you make a correct point that the corpus juris of antitrust jurisprudence has developed over the years on top of the text of the Sherman Act. But I think if you go to the Chicago Professional Sports League case, it describes the history of the quick look doctrine, and it actually developed from Professor Arita's academic writing, along with the Solicitor General's brief in the Board of Regents case. And in footnote 39 of that case, they talk about the application of the rule of reason in the twinkling of an eye for condemnation of restraints. But further flesh that out, quoting the Solicitor General's brief in note 42, describing that it's for condemnation. It's not for approval of restraints. And I think the example of the baseball antitrust exemption shows that this court has over the years come to regret the decision to create a zone of antitrust immunity, as the court in American Needle footnote 7 describes.
But excuse me, counsel. Under Board of Regents, the court held that if you don't have governing rules, you don't have a product. Are you claiming that the NCAA shouldn't be allowed to institute any amateurism rules for college athletics?
Your Honor, our position is that the NCAA may institute rules so long as they survive the full-on rule of reason analysis. And I'll let co-counsel discuss the way in which the rule of reason analysis was done in this case. But what we submit is that there's actually a bit of a bait and switch here. And again, I would point to footnote 7 of the American Needle case, which describes, there are basically two kinds of sports league restraints. On the one hand, you have the kind that Judge Bork described at page 278 of the Antitrust Paradox. Judge Easterbrook described as, a league with just one team is like one hand clapping. There are some restraints that you need to operate a league, but on the other hand, and this is what the NCAA says in this case, there are two different kinds of products. There's the amateur product and there's the professional product. But what the court in American Needle said was that—
counsel, excuse me, I'm sorry for interrupting, but I just am trying to understand, shouldn't there be that ample latitude given to petitioner? All right. I mean, they have created this product of college sports that have had, that have become an institution in this country. So shouldn't they be able to go through and have the latitude necessary to be able to define amateurism and to define college sports as we know it?
I think Your Honor reads the precedent correctly, and you're citing Board of Regents. But Board of Regents was about— it ended up coming to the same result, but it was on appeal from the 10th Circuit. What the 10th Circuit had done was applied the per se rule, and the Board of Regents case said at the Supreme Court level, Justice Stevens, you apply the rule of reason, and that's the way in which we allow ample latitude, that we're not going to just dismiss them out of hand. But what we're going to allow the NCAA to do is make their arguments within the context of the full rule of reason analysis. And so, if we're looking back at Board of Regents, the mere existence of pro-competitiveness in the restraint itself is not enough to bless the restraint at issue. And again, I'll let co-counsel talk exactly about the rule of reason. But the Amex case is the most recent black letter law statement of the doctrine on the rule of reason, where there's actually a third step. There's the narrow tailoring argument. So if the NCAA wants to make the case that the rule duly advances amateurism, I think this is actually a terrific test case for just how overbroad are we going to allow the NCAA to draw a regulatory control, then claim the deference accorded, but by virtue of the amateurism-related nature of the regulatory control. But we still need to go to tailoring.
Counsel, under the rules of the Little League, as I understand it, 12-year-olds can play and 13-year-olds can't. Could a plaintiff get a rule of reason jury trial on the question whether 13-year-olds should be allowed to play if, for example, they're shorter or thinner or less advanced than comparable 12-year-olds? I'm not asking if they can win. I'm asking if they can get to a jury.
Well, and Your Honor, I see that my time has expired, so I want to move over to my co-counsel at this point, but I will quickly answer that the question would engage the various precedents that we have at issue, most all of which have spoken to professional sports leagues or the pseudo-amateur league context of the NCAA, Little League would be different. You would still have to allege some sort of injury under the Sherman Act, but I think it would be a more complicated analysis, one not briefed before this court and not really as much at issue today. With that, I'd like to turn it over to my fantastic and talented co-counsel, Kit Matoyer, who will argue question 2.
Thank you very much, Ellie. You're always a tough act to follow. Good afternoon. My name is Kit Matoyer for respondents Alston et al. Your honors, and may it please the court. We urge this court to affirm the district court's injunction for 3 reasons. First, the NCAA badly distorts what we argue is a narrowly tailored and carefully balanced injunction that remains faithful to the underlying purposes of the Sherman Act, which is to vindicate injured parties' rights, while adhering to this court's teachings in Board of Regents that the NCAA does need ample latitude. Second, the NCAA's pro-competitive justification of amateurism is both incoherent and unworkable as a practical matter. And third, we argue that the NCAA not only blurs fact and law on appeal without stating the applicable standards, but the legal errors themselves are unavailing. And so to return to my first point on the injunction, what we're here right now, we're here on behalf of our clients who are trying to just vindicate their rights as given by Congress under the Sherman Act in 1890. And Judge Wilkin here managed to do that in a way that balanced the interests that Justice Stevens told us to be worried about in Board of Regents. And we argue that that is a narrowly tethered remedy to the injury. What Judge Wilkin here
Counsel, could I ask you a question? Excuse me for interrupting. I'm still trying to understand. I listened to your co-counsel and I'm listening to kind of the path of your arguments. But what I fail to understand is, who do you think is best to determine the appropriate guardrails for amateurism and competition at the college sports level? My colleague asked a question earlier that, are you going to expect that there's going to be a lawsuit every single time? Like who if it's not the NCAA that has its 100+ year history of managing and overseeing college sports, who then are you asking? Are you asking the court every time to come back and make a decision as to what amateurism is, and it's going to change every year and the rules change every year?
Sure, Your Honor. So what we argue here is it gets directly to step 2 of the rule of reason analysis. And this wraps up one of the NCAA's legal arguments as well. So at step 2, the NCAA is freely able to define their product. But what they weren't able to do at step 2 was do that. Their definition as they brought forward that student athletes must not be paid is riddled with exceptions. And so the problem here is that while at step 2, under the Sherman Act, parties are free to define their product, it's not assumed to be true, the definition that's posited. It must be proved. And when you look at what Judge Wilkin did here, it's the stuff of the trial courts. It's battle of the experts. It's like the in real-time witness testimony. And we argue that Judge Wilkin here didn't pull this factual determination out of thin air. Just looking at the record of the competing experts, for example, if you take the economic experts of each party, amateurism is central to the NCAA's argument because they say that as their conception of it, that players must not be paid, is what drives consumer demand, which is absolutely a pro-competitive justification at step 2. But there's just a couple problems with that. One, we don't know what it means to be paid. The NCAA's rules as they stand allow what looks like a lot of ways to be paid. And Visa gift cards.
Excuse me, counsel.
Yes.
Would you consider the fact that the NCAA has allowed for further compensation beyond cost of attendance scholarships like insurance policies for athletes, breaking the wall of amateurism? And how does that impact the NCAA's argument that amateurism is necessary to protect its product?
So, Your Honor, I would like to start by saying the above cost of attendance that the NCAA currently permits is exactly right, insurance that's related to the safety of the players, but also they're able to pull and to give funds from the 2 funds as it stands for things like groceries and parking and clothing. And so there's just really no distinguishing principle that allows us to move forward on what it means to what the NCAA proposes to be amateurism. And right now we argue that it's a moving target.
But counsel, it sounds like you're making it an all or nothing proposition. If the NCAA in its infinite wisdom got what one call more liberal, and they decided that college athletes in revenue sports could be paid up to $50,000 a year, you would attack it as too low. And if you wouldn't, somebody else would. And we would go off to another jury trial or another court trial in front of another judge to decide whether 50,000 is a good cutoff. You're really arguing for obliterating the amateurism concept entirely, aren't you? Because otherwise, how do you demonstrate the line drawing?
Sure. So one thing, Your Honor, that I would like to say there is I believe this is a good time to bring in Judge Stevens' language and Board of Regents about his conception of amateurism. So Justice Stevens says that amateurism is, and I quote, that players must not be paid, must attend class, and the like. And so whether or not this would destroy amateurism, I think ignores the other components of amateurism that are just as important. And that is that the athletes to the fans appear as students and school loyalty. And that's what we're really worried about here. And that's
but counsel, excuse me, no one's disputing that. I think you're evading my question, which is we appear to be moving toward an era in which more can be given to athletes, even under the NCAA's rules. And you could be viewed by a cynic as nitpicking and continuing to nitpick for as long as we go on with this until there are no amateurism rules at all. Is that where this is taking us?
So, Your Honor, I think 2 points on that I would like to make, and my co-counsel has alluded to this as well. I think the status of litigation that will come from this case, we argue is not considering fully what's at issue, and that is our players' rights to the vindication of their rights under the Sherman Act. And I worry that what Congress will do in the future or what states will do in the future, no matter how close it might be or what future litigation might look like, shouldn't be at the expense of the vindication of the players' rights here. And that's what we argue, and that's what we urge this court to uphold, is Judge Wilkins' very narrow, circumscribed injunction that declines the opportunity to touch any other compliance arms of the NCAA in terms of expenses that are untethered to education. They are free to continue to limit those, as well as from boosters. The injunction invites the NCAA to define education related. It allows them to decide the manner in which these education related expenses are to be distributed. And so I urge the court to not at the expense of the parties here when we're dealing with what we argue is a very narrowly tailored injunction that balances the ample latitude by rejecting two least restrictive alternatives too that would have given more would have been more broad to the players and would have obviously not been as much deference to the NCAA, and they picked the one that would allow the NCAA to retain the most deference. So, Your Honor, I believe I'm probably done here. So for these reasons, particularly for the vindication of our rights, or our players' rights under the Sherman Act, we ask this court to affirm the lower court's injunction that has been affirmed once below. Thank you very much.
Thank you. And for Notre Dame, who will take the 2-minute rebuttal? Right. Perfect. Okay, Paige, whenever you are ready, I will start the time.
Your Honors, respondents move the scope of this case. The narrow issue before the court is whether capping is pro-competitive or anti-competitive, and we argue that it is pro-competitive. Page 8 of our brief to the court outlines cost of attendance and what it includes. It includes room, board, books, computer, transportation, but it also includes miscellaneous personal expenses. Covering legitimate academic and athletic expenses falls in line with the cost of attendance, which Congress allows to be altered on a case-by-case basis. The line must be appropriate and reasonable, and we argue—
Hey, counsel, real quick, I know you're short on time, but I really have to ask real quick. When you say capping is pro-competitive, it's only capping what an athlete can receive. Everything else is incredibly competitive in terms of what everyone else in the sports space is getting paid based on the exploits of these athletes. So how is it that capping just this one particular piece is actually pro-competitive?
Your Honor, this challenge would not be appropriate or reasonable because it does not tether benefits to the student student athletes' academic success. Instead, it promises them unlimited benefits for the future. That's compensation for their status as an athlete. And that goes against the that goes against the court in Board of Regents and also in O'Bannon. So we also ask, Your Honors, what more is needed outside of the cost of attendance? Athletes can already draw on additional funds at their institution to support other areas of need. And let's also remember that the cost of attendance is the highest estimate. There is latitude built in. Discretionary spending is built in. The Sherman Act and the NCAA have existed.
It seems like all the discretion is on your client's part. You have discretion to change the rules, have them go up or down. The schools don't, the courts don't. It's NCAA is king. Is that your argument?
No, Your Honor, I would respectfully disagree. Our argument is that we are being limited by the courts limiting us to cost of attendance. Each school has its own cost tethered to it. And so this restricts us in a cost of attendance model. And the Sherman Act and the NCAA have existed together for over a century. Affirming this judgment would allow the finding of one judge to upset that balance. The courts below make college athletics a de facto professional organization. Related to education does not separate the benefits this injunction would allow from professional salaries, as is necessary under the holdings in Board of Regent and O'Bannon. The post-eligibility internships obviously would be paid in cash. No inherent actual cost is associated with an internship, and they can be promised during recruitment to sway athletes to select a certain school. Academic awards and incentives can be given simply for maintaining eligibility. And for these reasons, we respectfully ask the court to overturn the Ninth Circuit ruling today. Thank you, Your Honors.
Thank you very much.
Fantastic job, everyone. That was a fantastic hearing. Thank you so much to the judges as well. Everyone did a phenomenal job. I would leave this time if the judges want to have it, if they want to provide any constructive feedback that's positive. Just remember that we are live streaming, so please be positive.
I'd like to say that I thought everyone did an excellent job. You're all obviously prepared. I have my own thoughts as to, what really worked. I was very impressed with your contemporaneous responses, and you were all very much in tune with the law, and it was very impressive. Thank you so much for your time.
Judge Fedlin?
Yeah, I would agree. It was a pleasure. I really enjoyed this time. I say let's keep going, right? Let's just make some more arguments. I think you all did a fantastic job. Clearly, you spent a significant amount of time just synthesizing and absorbing all of this information, especially on some issues that are a bit tricky. So it was great. It was great learning from you all, hearing you all in your arguments. I think you did a fantastic job.
I would second or third what my fellow justices have said. I did moot court back when I was your age, and I've done lots of Court of Appeals arguments, one Supreme Court argument. You can't do this in 15 minutes. I mean, I'm blown away because you had to spend the time to think through how to do this in 15 minutes aside with two counsel. And it's exceptionally difficult, and you have to pick your spots. And we unfairly, I accused the NCAA of nitpicking. We nitpicked you because you can't possibly answer all the questions. This is a case that ought to be really argued longer than the usual time permitted by a court. It's got all kinds of nuances to it. And I just thought you did wonderfully in putting it all together and having a mastery of this thing. I mean, it's got a long history. I've watched it since O'Bannon was filed, and it's a lot of stuff to remember. And I'm not sure how much you knew when you started, but you know a heck of a lot now. So congratulations. You could go to court tomorrow and represent a client quite effectively.
Completely agree. I think, especially with the time constraints and how nuanced this case is, I mean, the NCAA's arguments are very technical based. And so to be able to put this all together within 2 weeks and understand the material and be able to respond and argue it in moot court is an incredible feat, and everyone deserves a lot of credit. Thank you so much, everyone, for participating. Judges, please take the next 15, 20 minutes, 30 minutes max, please, and send me back the scorecards, or just the scores in an email is fine. That way I can let the participants know, because one of the teams is going to be arguing in the finals tomorrow, and they'll need to know for tonight. So thank you so much, everyone. It has been a pleasure. Thank you, judges and law students. You guys did an incredible job.
Thank you so much.
Thank you very
Well
much.
done, everybody.
Thank you. Be safe.
Thank
Best
you.
to you all. Bye-bye.
You too.